English legal shorthand 100 words per minute. Ready? Start. Mr. Patak, learned advocate appointed through the Legal Aid Department to assist the court, would submit that the definition of industry under Section 2 bracket small j of the ID Act stands settled by the decision of the 7-judge bench of the Supreme Court in the case of Bangalore Water Supply and Sewerage Board versus capital A. Rajappa and others. Stop. Wherein even small scale industry or individual engaging a few persons was held to be within the ambit of industry. Para. He would submit that in the present case, the activity of operating a laundry with 4-5 employees would therefore come within the definition of industry. Stop. He would submit that the primary object of Section 36 of ID Act is to regulate representation of parties before the tribunal and to maintain balance between the workman and employer. Stop. He would submit that under Section 36 bracket 3 of the ID Act, engagement of legal practitioner is restrained while Section 36 bracket 4 carves out a limited exception permitting representation by a legal practitioner with two conditions, that is, first, with the consent of the opposite party, and second, with the leave of the court or tribunal. Para. He would submit that refusal of such representation by the court cannot be exercised mechanically or on mere objection by the opposite party. Stop. He would submit that court must examine the facts of each case and determine whether denial of such representation would cause prejudice or violation of the principles of natural justice and lead to any disbalance between the parties before the court. Stop. He would submit that the above provision was enacted with the object to ensure fairness by preventing parties from gaining an unfair advantage through legal representation was then a real issue when employees were not represented by their unions or advocates, which were not within the reach of employees, and it derived them adequate representation. Stop. He would submit that the period in which this act came to be enacted pertained to an era when litigation could not be said to be between equals and the nature of industrial activity was limited. Stop. He would, however, submit that the earlier position no longer prevails in present times. Para. In support of his submissions, he has referred to and relied upon the decisions of the Supreme Court and this court in the case of Pradeep versus their workmen. Industries India bracket Private Limited versus Suresh Maruti and others. Yashwant Harish Chandra versus Chairant Chemicals India Limited, Mumbai, and A.S. Muhammad Rafi versus State of Tamil Nadu, represented by Home Department and others. Stop. Wherein the legality and sanctity of Section 36 of ID Act stands affirmed. Stop. He would submit that the said provision must be interpreted harmoniously, thereby giving due effect to both the legislative intent of maintaining equality in industrial adjudication and the overreaching principles of natural justice, fairness, and due process of law. Stop.